of the court while maintaining an equal aspect towards all litigants as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes.
Yes.
This is, my Lord, I think
you are saying it comes under this too?
Lord, what I'm saying is that these are the provisions which can be...
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because, my Lord,
we have an advantage in having you before us.
My Lord, I'm grateful for
the advantage is you are now well versed with SJC matters.
Lord.
Okay. The other SJC matters where you are proceeding again. One is finishing a complaint, right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where you proceeding against a judge? Why you proceed against a judge? With a view to remove him. So you have to give him some... I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट. जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे पूछे. उन्होंने एक तकरीर में कर दी. दूसरा तरीका आप बता दें कि कैसे कर सकते हैं.
उसका तरीका मैंने बताया ना. जो एलिगेशंस लगा रहे हैं व्हाट इज I am again, let me reiterate, I am not taking sides. I am saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there's nothing beyond that. Article 5 or at the subpara 2 of Article 2. And this is for this honorable court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So they were, and those specific allegations are not there in the speech. The order itself, when we read page 7, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is going back to the observation.
Is it the status which?
No, not at all. Not at all. It was just. I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something. Therefore, believe him and not believe the other part. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, this is fine, this is all right, this does not amount to misconduct, then the order that this honorable court has to pass, the way to move forward, is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be
But if you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the audit itself. Okay. What the conclusion would be then that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this Honorable Court wants to go into whatever the petitioner it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, what would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How will you get to it?
What I'm saying is that not in this list, not in the case before
how
your
do we
lordship,
do it?
that your lordship takes suo motu action or takes some other action, but not it cannot be.
इनकी एक तजवीज़ आई है कि send it for review, remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको solve करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he's sticking to that the matter can go back to the Supreme Judicial Council.
Can it?
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he's removed, recommends to the President, remove him. That's it. End of story.
The petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person. It's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Who was telling the truth? Well, truth doesn't matter anymore. I keep emphasizing on truth if he's the truth, I think all the maslas will go away.
No, just as it was open.
Aren't you personally interested just to know?
No, yes, may I make a submission?
Isn't it burning inside you?
Well, not within the framework of law, within the framework of constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास
नहीं ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, एक कंप्लेंट हमारे पास पढ़ने नहीं बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद है, मैंने कहा चलो हटा दो इसको, सारे हमारे सुप्रीम जुडिशल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं.
पिटीशन आती है, एक पिटीशन.
अगर देखिए एक बात है सब्स्टिट्यूटिंग योर ओपिनियन फॉर someone else, that's a different matter. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even someone commits murder right in front of 100, 200 people sitting in this room. We can't just say hang him. No, we'll have to frame a charge. We'll have to bring witnesses. We'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, each decision creates a precedent. So where should we go now from here?
As I keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion.
Then the nation will hold us accountable.
Necessary, notwithstanding the allegations made.
If you have finished, can we request the Attorney General? Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late? Let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, is finds mentioned twice, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I'm concerned. ये इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, बस हवा में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now, we were hearing some other case.
Yes.
The same issue came up there also.
So, my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned. 211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments doesn't.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this